Hello, everybody, and welcome to this episode of Esquired. We are going to be introducing the COVID-19 series today. As I'm sure we're all aware by now, the United States economy and indeed global commerce came to a screeching halt in March 2020. The novel coronavirus, or COVID-19, as you've probably heard it, created unprecedented challenges for legal scholars and will continue to do so in the years to come. One law school, Seton Hall in South Orange, New Jersey, even decided to create a class regarding the impacts of the pandemic. This episode of Esquired is the first in the COVID-19 series in which I will be discussing some of these unprecedented challenges, and in this bonus episode, I will be talking about PPP loans. But first, your daily disclaimer. The information provided on this podcast does not and is not intended to constitute legal advice. All information, content, and materials available on this podcast are for general informational purposes only. Information on this podcast may not constitute the most up-to-date legal or other information. Use of and access to this podcast or any of the links or resources contained within do not create an attorney-client relationship between the listeners and podcast contributors. This includes contributing law firms or guest podcasters. Listeners of this podcast should contact an attorney to obtain advice with respect to any particular legal matter. No listener of this podcast should act or refrain from acting on the basis of information on this podcast without first seeking legal advice from counsel in the relevant jurisdiction. This podcast contains references to third parties. Such references are only for the convenience of the listener. Esquired LLC and its members do not recommend or endorse the contents of the third parties. All right. I want to get straight to it, but before I begin, just FYI, if you hear like something that sounds like a collar shaking or something, I want to let you know it's just my dog. I figure we can all have some wholesome content in the midst of everything going on here. So if you hear that, I'm not going to edit it out. His name is Harvey. I hope you enjoy. But, you know, if he starts barking or something, of course, I'll edit that out. But wholesome content only. Let's get right to it. Congress created the Paycheck Protection Program, or PPP, through the Coronavirus Aid, Relief, and Economic Security Act, otherwise known as the CARES Act, which President Trump signed into law on March 27, 2020. For those who are legally inclined, you can find the full act by searching for Public Law Number 116-136. The PPP modified the Small Business Administration's, or the SBA's, 7A loan program and created new business loans. Congress created PPP loans, allocating an initial $350 billion to the SBA in an attempt to incentivize small businesses, i.e., usually those under 500 employees, to keep their workers on payroll throughout the coronavirus pandemic. As of May 12, 2020, Congress allocated $670 billion toward the loan program, and as of May 16, 2020, the SBA approved over 4.3 million loans, totaling over $513 billion. And as an FYI, guys, I will make sure to post all of my sites to this podcast in the description below, just so you can find where I'm getting all of this information. All of them are also hyperlinked in the corresponding blog post if you go search that. But I will make sure that you can find everywhere that I'm finding this information. So anyway, initially, as incentive to seek a PPP loan, the SBA promised to forgive the loans so long as the business adhered to the following requirements. First, the business must keep all employees on the payroll. If you heard that caller, that was Harvey. First, the business must keep all employees on the payroll for at least 8 weeks after receiving the loan. Second, the company must maintain employee compensation levels for at least 8 weeks after receiving the loan. And third, the money may only be used for payroll, rent, mortgage, interest, or utilities. Note that at least 75% of the loan must be used for payroll. Loan recipients may only use a maximum of 25% of the loan for rent, mortgage, interest, etc., anything else that the requirements of the loan or that the loan can be used for, but at least 75% of the loan must go to payroll. The loan matures, i.e. payment becomes due in full, 2 years after dispersal and carries an interest rate of 1%. Additionally, the SBA will defer payments on the loan for 6 months, i.e., you do not need to pay anything on the loan for 6 months. For more information, check out the SBA's Paycheck Protection Program website, which will be in the description of this episode below, and also, like I said, on the blog. The hope was that PPP loans would thereby lessen one of the financial burdens small businesses were and are still facing: how to pay their employees, rent, etc. As such, companies jumped at the chance to receive forgivable funding. However, in the madness that was the initial impact of COVID-19, neither the government nor borrowers completely thought the loans through. Although PPP loans carry loan forgiveness provisions, their terms have been up for interpretation and have been confusing to some small business owners. Indeed, since the PPP's creation in late March of 2020, the SBA has enacted numerous rule changes, and as of this podcast, it's only mid-May. So what now? Well, the Treasury intends to audit any loan forgiveness applications that seek forgiveness in excess of $2 million. This, in turn, has resulted in some companies actually returning their loans to the SBA in fear of failing to abide by the loan's forgiveness provisions. One of the biggest concerns is whether the company properly certified the quote-unquote necessity requirement, which is a part of the borrower loan application. To receive PPP funds, borrowers needed to certify that the quote current economic uncertainty makes the PPP loan requests necessary to support the ongoing operations of the applicant, aka the business. But what is necessity? The SBA has yet to comment. Unfortunately, those borrowers that have received above $2 million could face significant litigation if the government finds that the loan was not, quote, necessary. Potential issues may include audits, civil penalties, and criminal prosecutions. Most notably, practitioners have flagged potential civil suits under the Federal False Claims Act, or the FCA, which you can find starting at 31 U.S.C. Section 3729. And if you check out our blog post, there's also an article that I linked in which you can find more information about the FCA. Also in the blog post and linked down below is an article from Bloomberg Law written by two attorneys from the multinational firm Morgan Lewis. They state that, quote, liability arises under the FCA when a person knowingly submits a material false claim for payment to the U.S. government, or where a person submits a claim with deliberate ignorance or reckless disregard for the truth of the information in the claim. Now, the biggest issue with liability under the FCA, however, is that liability could result in what we call treble damages. Treble damages simply means the company would be on the hook for repaying the government triple what it borrowed, i.e., for every $1 it borrowed, the company would owe the government $3. Yikes. So this is obviously a concern that businesses that borrowed over $2 million have. The deadline for returning PPP loans was Monday, May 18th, 2020, though. So if a company is still considering returning the loan, it's kind of out of luck, for now at least, unless the SBA reopens it or something like that. The good news for borrowers that obtained over $2 million is that the SBA will allow these companies to pay back the loan in full should the government find that the loan was not necessary. Additionally, the SBA has stated as of May 13th, 2020, that so long as the borrower repays the loan after notification from the SBA that the loan was not necessary, then the SBA, quote, will not pursue administrative enforcement or referrals to other agencies based on its determination with respect to the certification concerning necessity of the loan request. The other good news is that the SBA issued guidance regarding the necessity requirement for companies that borrowed less than $2 million. As of May 13th, 2020, the SBA's position is that, quote, any borrower that received PPP funds with an original principal amount of less than $2 million will be deemed to have made the required certification concerning the necessity of the loan request in good faith. In essence, that's a huge relief for those companies because those companies that borrowed under $2 million now don't have to worry about meeting that quote unquote necessity requirement. It's going to be presumed. But do remember that those companies must nonetheless follow the other terms of the loan, which I discussed earlier, to be eligible for forgiveness. I implore anybody who has a PPP loan already or is looking into PPP loans or really anything to do with the CARES Act and this whole pandemic. The pandemic is, well, the laws and legal implications of the pandemic are complicated. I implore all of you to seek an attorney if you feel that you need one, and they can help you, navigate this unprecedented terrain. Down below, I included the link to the PPP's forgiveness application. You can also check out the most up-to-date SBA guidance as of May 13th, 2020 down below. Only time will tell how all of these uncertainties play out, but one thing we can be sure of is that legal issues surrounding COVID-19 are far from over. In fact, they're just beginning. For additional information about PPP loans and their interplay with bankruptcy, check out the article I wrote on LinkedIn, which I linked in. Linked in below. Until next time, be well and feel free to get in touch with me at contact@esquiredpodcast.com. Don't forget to check out the corresponding blog post at www.esquiredpodcast.com. And if you're feeling generous, I encourage you to leave a review on this podcast. Until next time, have a great week.